Thank you for visiting the Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 400 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Domestic violence defense lawyer in Southern Illinois. A Southern Illinois domestic violence defense lawyer represents individuals accused of domestic battery, harassment, or related offenses under Illinois law. These charges are extremely serious. They can result not only in jail time and steep fines, but also long-lasting consequences, like the loss of firearm rights, difficulty finding employment, and restrictions on child custody. If you are facing allegations of domestic violence in Southern Illinois, your reputation, freedom, and future are on the line. Southern Illinois courts treat these cases aggressively, and prosecutors are under heavy pressure to secure convictions. Having the right Southern Illinois criminal defense lawyer at your side can make the difference between conviction and a dismissal or not guilty verdict. Don't wait to protect your future. Call Waterkotte at 618-88-CRIME or contact us online for a free, confidential consultation. Things you will learn from this video about domestic violence cases in Southern Illinois. Domestic violence can be charged as a misdemeanor or felony, depending on the severity and prior convictions. Penalties include jail, fines, probation, and orders of protection. Convictions often result in loss of firearm rights, employment difficulties, and custody issues. Defense strategies may involve self-defense, false accusations, or lack of evidence. Hiring a defense lawyer immediately can change the course of your case. What counts as domestic violence in Southern Illinois? Illinois law defines domestic violence as a pattern of abuse directed toward a family or household member. Importantly, it is broader than just physical harm. The law also covers emotional, psychological, and controlling behavior. Under the Illinois Domestic Violence Act, abuse includes physical abuse, any act causing bodily harm. Harassment, repeated or threatening conduct intended to cause emotional distress. Intimidation of a dependent, using threats, coercion, or control to instill fear. Interference with personal liberty, restricting another person's freedom of movement or decision-making. Willful deprivation, denying an individual necessary care, assistance, shelter, or access to basic needs. These protections apply to a wide range of family or household relationships, including spouses and former spouses, current or former dating partners, parents, children, and stepfamily members, individuals who live or have lived together, co-parents, regardless of marital status, disabled or elderly adults and their caregivers. This broad definition means that many types of conduct, even without physical injury, can be the basis for a domestic violence case in Illinois. Charges and classifications for domestic violence in Southern Illinois. The severity of domestic violence charges depends on the circumstances. Domestic battery, Class A misdemeanor. A first-time charge without aggravating factors is usually a Class A misdemeanor, punishable by up to 1 year in jail and fines up to $2,500. Aggravated domestic battery, Class 2 felony, involves strangulation, use of a weapon, or causing great bodily harm. Penalties include 3 to 7 years in prison, or longer if extended terms apply. Repeat offenses. Prior domestic violence or violent crime convictions can elevate new allegations, turning a misdemeanor into a felony and increasing sentencing ranges. Violating an order of protection, ignoring the terms of a protective order, is a separate criminal offense. First violations are often misdemeanors. Repeat or aggravated violations can be charged as felonies. Interfering with the reporting of domestic violence, typically Class A misdemeanor. Preventing or attempting to prevent a victim or witness from calling 911, seeking medical help, or reporting the crime. Stalking, safan, aggravated stalking, repeated following, monitoring, or threatening that causes fear or emotional distress. Often charged alongside DV when the parties are family or household members. Intimidation, felony. Using threats to coerce someone to act or not act, including threats of harm, confinement, or other unlawful acts. Unlawful restraint, felony. Detaining or confining another person without legal authority, sometimes charged where movement or liberty is restricted in a DV incident. Criminal trespass to residence, entering or remaining in a residence without authority, frequently alleged in domestic contexts after breakups or protective orders. Harassment/harassment by electronic communications, repeated, threatening, or abusive calls/messages that cause emotional distress, often charged as standalone misdemeanors or as part of a DV case. Statutes vary by conduct and medium. Child present enhancements. Offenses committed in the presence of a child can trigger mandatory minimum penalties, counseling requirements, and stricter probation terms. Penalties and consequences of a domestic violence conviction in Southern Illinois. The immediate penalties of a domestic violence conviction are severe, but the collateral consequences can be even more damaging. Jail or prison sentences, depending on whether the offense is a misdemeanor or felony. Fines and restitution. Courts can impose heavy fines and order repayment to the alleged victim. Mandatory counseling or programs. Judges often require anger management or domestic violence intervention programs. Orders of protection. Convictions typically result in no-contact orders, loss of access to the home, or loss of child visitation rights. Firearm restrictions. Federal and state law prohibit those convicted of domestic violence from owning or possessing firearms. Custody and family law impact. A conviction may be used against the accused in custody disputes or divorce proceedings. Criminal record. Domestic violence convictions remain on your record permanently, making employment, housing, and licensing more difficult. Defense strategies in Southern Illinois domestic violence cases. Every case is unique, but there are proven defense strategies that a skilled Southern Illinois domestic violence defense attorney may use to fight domestic violence charges in Southern Illinois. Self-defense, demonstrating that the accused acted to protect themselves or another person. False accusations. Domestic violence claims sometimes arise in the context of custody battles, divorces, or personal vendettas. A defense lawyer can uncover the motive behind false claims. Lack of evidence. Prosecutors must prove guilt beyond a reasonable doubt. If there are no injuries, unreliable witnesses, or inconsistent stories, the case may collapse. Procedural errors. If police violated constitutional rights by conducting illegal searches, seizing evidence without a warrant, or mishandling interrogations, evidence can be excluded. Mutual combat. In cases where both parties willingly engaged in a fight, charges may be reduced or dismissed. The right defense strategy depends on the specific facts of the case. A Southern Illinois domestic violence defense attorney can begin building your defense right away. What happens after a domestic violence arrest in Southern Illinois? Understanding the legal process can reduce the fear and uncertainty that comes with an arrest. Arrest and booking. Police take the accused into custody, record charges, and hold them pending a bond hearing. Bond hearing. A judge decides whether the accused can be released, and under what conditions. Protective order hearing. Judges often issue orders of protection, restricting contact between the accused and the alleged victim. Pretrial motions. Defense lawyers may file motions to suppress evidence or dismiss charges. Discovery and negotiations. Both sides exchange evidence. Plea deals may be discussed. Trial preparation. Defense counsel builds the case, including gathering witnesses and consulting experts. Trial. Evidence is presented before a judge or jury. Sentencing and appeals. If convicted, the defense may argue for reduced sentencing or file an appeal. Having an experienced Southern Illinois domestic violence defense lawyer guide you through each stage can make the process far less overwhelming, and they will be able to protect your rights and freedoms at every stage. FAQs about domestic violence charges in Southern Illinois. Can domestic violence charges be dropped? Yes. While prosecutors control the case, charges may be dropped if evidence is insufficient, witnesses recant, or the defense undermines credibility. Is domestic battery always a felony in Illinois? Number A, first-time offense without aggravating factors is usually a misdemeanor, but repeat or aggravated cases are charged as felonies. What happens if I violate an order of protection? Violation of an order of protection is a separate criminal offense and can result in additional jail time, fines, or felony charges. Will a conviction affect my custody rights? Yes. Domestic violence convictions are often used in custody battles and can severely limit parental rights. Do I lose my gun rights after a conviction? Yes. Federal and Illinois law prohibit individuals with domestic violence convictions from possessing firearms. Speak to a Southern Illinois domestic violence defense attorney today. If you or a loved one has been accused of domestic violence in Southern Illinois, do not wait to get help. The sooner you involve a domestic violence defense attorney in Southern Illinois, the better your chances of protecting your future. Call Combs Waterkotte today at 618-88-CRIME or contact us online for a free, confidential consultation with a Southern Illinois domestic violence defense lawyer.